Good evening to all of you. I would like to extend a warm welcome to all of you to this Indian Judicial Colloquium hosted by OP Jindal Global University and Jindal Global Law School in knowledge partnership with Live Law. We have today a very distinguished set of judges from the high courts across India and also a Chief Justice of High Court. The theme of today's colloquium is delivering justice in difficult times, the role of judges and courts. COVID-19 is not only the most unprecedented health crisis of our times, but also an economic and humanitarian tragedy. India has crossed the 2 million COVID-19 case mark and has, as the world's largest democracy, our next steps will have a bearing on the entire world community, socially and politically. While human lives are the largest price paid during this epidemic, the collateral damage is definitely visible in the breadth of disruptions in justice, ranging from lack of equal access to healthcare, to unemployment, to unfortunate cases of domestic violence and other challenges in relation to access to justice. While we witnessed large-scale loss of life and severe human suffering, enabling the justice system is even more challenging. Our judiciary is the guardian and protector of our constitution and our basic fundamental rights. However, with the required state of emergency lockdown, we stand at the brink of a unique paradox of protecting our constitutional rights on the one hand, while we are to some extent being asked to temporarily suspend the same in some cases. Being in a state of quarantine and social distancing has not only added to the demands of justice, but also limited the operations of our courtrooms and indeed litigation. Access to justice is temporarily deferred, if not paralyzed. Our judges and courts stand at a redefining moment today. A proactive approach will help insulate our legal system from a possible breakdown. As the Supreme Court of India laid down the guidelines for video conference-enabled courtrooms, and as many high courts across India have provided leadership, India has taken the leap to embrace technology and propel law into the digital age. It is evident that COVID-19 may possibly turbocharge a transformation in the Indian judiciary. And our actions today will help redefine the state of justice for a better future of our nation. Therefore, today's colloquium is a very important platform to address the role of judges and courts in delivering justice in difficult times that we face today. I have great pleasure in welcoming a fantastic group of judges, beginning with Honorable Mr. Justice Banerjee, who is a distinguished judge of the Calcutta High Court. Justice Banerjee has practiced in the High Court of Calcutta, as well as the Supreme Court of India, High Court of Delhi, Bombay, Allahabad, Patna, Jharkhand, Guwahati, Orissa, and many other states. He has also practiced in Company Law Board, Delhi Securities and Appellate Tribunal, Debt Recovery Tribunal, as well as specialized in corporate and intellectual property law matters. Welcome, Justice Banerjee, to this colloquium. We have with us Honorable Dr. Justice Vineet Kothari, who is a distinguished judge at the Madras High Court. As a lawyer, practiced in tax and other commercial and constitutional laws, arbitration and company law for 20 years at the Rajasthan High Court and the Supreme Court of India. He is a member of the Institute of Company Secretaries of India, the Institute of Chartered Accountants of India since 1982. He is a former judge of the Karnataka High Court and the Rajasthan High Court. Welcome, Justice Kothari.
Thank you. Thank you.
We have with us Honorable Ms. Justice Geeta Mittal, the Chief Justice of the High Court of Jammu and Kashmir. She is the first ever female Chief Justice of Jammu and Kashmir High Court. She is the former Chief Justice of the Delhi High Court. Justice Mittal received the Distinguished Alumna Award in 2008 from the Vice President of India, awarded by the Lady Shri Ram College for Women. In 2018, President Ram Nath Kovind awarded Justice Geeta Mittal with the Nari Shakti Purushkar, India's civilian honor for women. She is a distinguished judge and also has a very strong academic bent of mind. Welcome, Justice Mittal, to this colloquium. We have with us Honorable Mr. Justice A.K. Jayasekaran Nambiar, a distinguished judge at the High Court of Kerala, an alumnus of Oxford University, UK. He commenced his practice as a lawyer in 1990 with Ms. MS Menon and Pai Associates, a leading law firm in Cochin, specializing in constitutional law and taxation, direct and indirect. He was designated as a senior advocate of the Kerala High Court in July 2011. In 2014, he was sworn in as an additional judge of High Court of Kerala. He was appointed as a permanent judge of the High Court of Kerala in 2016. Welcome, Justice Nambiar.
Thank you.
We have, of course, Honorable Mr. Justice Aparesh Kumar Singh, a distinguished judge of the High Court of Jharkhand. He belongs to an illustrious family associated with the judiciary. His maternal great-grandfather, late Sri B.P. Sinha, was the 6th Chief Justice of India. He himself has enrolled as an advocate in the year 1990 and had a very distinguished practice at the Patna High Court from 1990 to 2000 and in Jharkhand High Court since 2001 till his elevation as a judge. Welcome, Justice Aparesh Kumar Singh.
Thank you.
First of all, I would like to extend a deep sense of appreciation to all of you for having accepted our invitation and to be part of this evening's colloquium, particularly after a long day of work in your respective high courts. So thank you very much. Let me begin my first question to Honorable Ms. Justice Geeta Mittal. Justice Mittal, the very foundation of a nation's response to the current pandemic crisis is the law and its impact as a social institution. What are your views on the effectiveness or otherwise of the Epidemic Diseases Act of 1897 and the Disaster Management Act of 2005? Would it possibly help to have a more customized set of laws and regulations, borrowing on the rich tradition and even the practice of the UK's Coronavirus Act and the Singapore's infectious diseases regulations? What can we imbibe from these experiences of other countries to brace ourselves for a more robust response to a future crisis? Justice Mittal.
First of all, I'd like to warn you that I can't say much on this because, worrying about the ineffectiveness of a legislation of 1897, I've already formulated a question as part of the ongoing consideration in court. And it is directly an issue before me in court. So it wouldn't be appropriate for me to go into the issue. I've said much on it with regard to it on the order. More specifically in the context of dealing with the aspect of violence against healthcare workers, which has got very exacerbated at the time of this pandemic and the crisis which it has generated. But leaving the two legislations aside, what I would like to say is that the experience of England and Singapore really may not be of much use, keeping in view the size of the countries and the population, the demographies, the discipline of the people there. Our greatest failure so far as effectiveness of legislation arises from the fact that we are unable to implement the laws and the inability on our part and our institutions to enforce regulatory mechanisms. So, but there are certain very important and significant measures which have been highlighted in those acts which relate to ensuring health of parties, which are very significant, and India can draw much from not only the legislation but mostly from the manner of implementation. So you'll excuse me, Dr. Rajkumar, from commenting more on this aspect.
Sure. Thank you very much, Justice Mittal. Well, for all those who are watching this show, we are live on Facebook and YouTube, and I invite you to send in your questions. After the first segment of what we are doing now, we will take up your questions as well. Let me move to Justice Nambiar, because it's only appropriate that we move from Kashmir to Kerala all the way. Now, our community in general is likely to be plagued by disruptions born during COVID-19, such as commercial disputes, loss of employment, cyber frauds, and many other aspects. How do you imagine the landscape of high court cases and litigation to evolve in a post-corona world? How will this impact the judges, advocates, litigants, and various other stakeholders of the Indian judiciary? In fact, the real question is, in the given context, the corona-bound legal cases, how critical it is to prioritize court operations and legal services as essential services during the pandemic. That's Nambiar.
I don't think it is in dispute that the pandemic and the lockdown that is imposed in connection with that has brought in its share of woe for almost every citizen in this country. And when it comes to the problems that we face, the disruption of the economic planning, of the financial planning of everybody comes to the forefront. Now, of course, when you have a disruption in your economic planning, whether it be under a contract relationship or even in an employer-employee situation, this would create a heartburn, and this would create a stalemate, as it were, for the employers as well, and also for the contracting parties. Now, you were referring to the pandemic-specific legislations, and Singapore and UK have toyed with those things. And as Justice Mittal pointed out, there is a difficulty in employing similar measures in India because we have, of the sheer size and the population that we have. So, but having said that, it's not as though we are remediless, because we've often found that whenever there is a lack of legislation in our country, the courts have always stepped in. Correct. And that brings me to your point with regard to whether we need to prioritize. Of course, we need to prioritize, because whenever there is a lockdown, we face a situation where the courts cannot shut down, no matter what, because as long as there is a semblance of governance happening in the country, the courts need to be sitting so as to protect the civil liberties of citizens. And we realized that very soon in Kerala, almost immediately after the lockdown, we initially thought we'd shut down the courts also for some time, because we didn't know what we were grappling with and the extent or the magnitude of this particular epidemic. But we overcame that, and once we had some initial inputs with regard to what we were facing, we decided that we must at least have one court sitting, at least in virtual mode. And we did that quite admirably, to be frank, because the judges were all sitting from their homes and operating from their homes. The court staff were operating from their homes. The files were being transferred electronically, and a whole lot of things which we were till then only speaking about in the computerization conferences that we have ever so often. And suddenly we had things happening, and this was magical as far as I was concerned. But it was also magical for society in general, because we came across instances of one or two instances, to be fair to the government also, of police excesses, probably on account of the fact that they too were not aware of what they were dealing with and how to control the mob, and the citizenry was also not responding properly. So we realized the necessity of holding court sittings then. But on the aspect of prioritizing, I would think that when we're dealing with a situation where there is no legislation in force to guide your thing, we step in as we do in every other case where there is a lack of legislation. We invoke the provisions of the Constitution and we come in just to ensure that there is a rule of law. And therefore, there is no prioritization, because this is just another instance where we are acting as a court.
Thank you very much, Justice Nambiar. Let me move to Justice Banerjee. Justice Banerjee, sitting in the Calcutta High Court, I can imagine the extraordinary sense of double whammy crisis that people in West Bengal and institutions in West Bengal are facing. While the COVID crisis is on, you had to face the cyclone situation as well. And so in this context, if you can share a bit about what kind of role that the court as an institution has played during this time, and how it has been able to reimagine the justice delivery mechanism as we continue to face the current crisis more acutely in the context of West Bengal.
Over the last 3 months, we've all transformed in how we function, in how we think, and how we project ourselves. So that kind of change has happened now, to the extent that, future running to the airports to catch a flight at the last moment to attend a meeting will probably be, an exception and not the rule. For long, we've been trying in Calcutta to ensure e-filing. And we were facing resistance because it was not something which was done. The status quoists always resist. There was no resistance for any good reason. But when the courts were shut and virtual courts or video link courts were the only alternative, we saw suddenly technology being embraced in such an overwhelming manner. And we have petitions coming in filed electronically at 4 o'clock, at 3 o'clock in the morning, and we had to give time limits till when we could accept it, because we didn't think that it would be like this. But as far as the larger question of Cyclone Amphan, the double whammy of the lockdown, I'll begin with a small incident of the Andaman and Nicobar Islands, which the Calcutta High Court also serves. It was at probably 1 or 2 o'clock in the morning that a couple of senior judges got phone calls and messages from Andaman lawyers saying that there was no protocol in place to deal with the lockdown in the Andamans. And they were calling or they were sending messages at that time because they had connectivity issues. Otherwise, the whole day they didn't have too much of an internet connection to be able to come through. And on the basis of their short 4-line, 5-line WhatsApp complaint, a PIL was started and the Chief Justice's bench took it up, and with the cooperation of the Additional Solicitor General who was assigned to the matter, a protocol was set up. Similarly, when in the Andamans, flights started, and again, there was no protocol of quarantine or anything. Flights just started. And what to do with people who are coming in? There was no protocol. Again, that matter was revived and certain orders were put in place. And again, with the cooperation of the central government, certain rules and other things were framed. As far as the cyclone is concerned, it's too early now, even for an appropriate assessment to be made. It's something that I have never seen in my life, rains like this and the intensity of the rain. In Calcutta city alone, more than 15,000 trees have been felled. There are places where saline water towards the Sundarbans have come in and inundated farmlands. For years together, those lands become unproductive and they won't be able to grow anything. We are still in the process of assessing the extent of damage. But yes, though we have had no litigation yet or public interest litigation on Ampan or its after effects, disaster management teams and other agencies, particularly NGOs, have reached out, and apart from the deaths, there's no real human problem over there, which impedes the day-to-day living and functioning. But yes, in all this, courts are important. As Justice Nambiar says, the court never shuts down. We remain open all the time. Technically, you can knock at our doors even at midnight, and we wake up and we take matters, because that's what we are there for, to uphold the rule of law. But it's been an education throughout this entire process, and we hope that we never have to go through this again.
Thank you very much, Justice Banerjee, for that really compelling tour de force on the situation that you're facing. Let me move to Justice Kothari. Justice Kothari, one of the things that many judges are reflecting is also how they are constantly being asked to adjudicate issues that are not only caused by the current crisis but also pre-existing issues. Now, sitting in the Madras High Court, there are similar issues I'm sure you're facing. So one of the things that I want to ask you is that, and many viewers I'm sure will be keen to know, is that how does the court as an institution function when it comes to political executive taking complex decisions, keeping in mind the current crisis? In some ways, institutions like the courts tend to be far more differential with elected governments during these times of crisis. So how does the delicate balancing act a court like yours performs during these times? Justice Kothari.
I think the question touches the heart of the way of working the courts are doing in past 3 months. And I think we walk on a tightrope in these situations when we have to balance the things between constant policy decisions made by the executive and governments and the court's overview or judicial review, as you call them, is to be done. In past 3 months or so, mostly the flow of litigation in the courts has been urgent PIL petitions. And I think we have touched almost all issues, right from the holding of the board examinations to the giving of relief packages to the medical treatment of the people, the overcharging of the hospitals by private hospitals, this and that. I don't know any subject was left out from the court's reach in these times. So we are virtually like overseeing everything, but we have to balance always the constitutional fundamental rights and the policy decisions of the state government. You are right. We can't overreach the executive and the state decision making. We have to respect that because we expect those decisions to be taken on a consideration of a wide variety of the factors which the executive or the state government does. But then certain decisions of the state governments always have wider implications and effect on the general citizenry of the state. Even like passes, interstate movements, all these values or things which have in the past 3 months we have faced in COVID. The COVID has taught us many lessons and many new shades of cases are coming. Mainly, actually, we have almost forgotten dealing with the traditional disputes in the courts like land disputes or service jurisprudence or tax matters for that matter, which was our main bone of the litigation. But then we have not only been able to come out, meet these challenges in a very nice manner, I would say, in a very balanced manner. And thanks to the lawyers community also who have helped us in arriving at those decisions in a very rational and balanced manner. So far we think the High Courts and Honorable Supreme Court have played a very proactive leadership role in upholding the values of the Constitution and laws. And I may just add a few words about the question number 1, which you posed to Justice Mittal also. But she obviously expressed her inability to express much on that because of the question is framed. The problem is not of the sufficiency of law. Honorable Chief Justice rightly pointed out that the problem is in implementation. Since this COVID is, I believe, a problem which is worldwide and common to at least all the states of our country, India, I think a uniform code, I would say, drawing from all possible sources would have been far better, and uniform policy decisions also taken at one level would have been far better. If you allow all the states and even municipal corporations to take decisions at their own level, the whole lot of confusion arises, and that gives rise to a lot of litigation which is on the board of the courts during these times. And as you know, the court judgments and decisions can also be different in different situations from different high courts. So that is one problem where the judiciary, I think we are 24 high courts plus 1 Supreme Court, 25. So now we have to act in a kind of unison because the population at large, the citizenry at large, should not feel more confused by our actions. They should feel protected and safeguarded by this. So I think we have learned many lessons. We are doing our job in best possible manner, given the framework of situation which we are in. And I think judiciary should be given 3 cheers for this. I should not applaud myself, but all as a whole, the judiciary has done a wonderful job. At the same time, the government has also done a wonderful job in these difficult times. But yes, all of us are finally to serve the public at large. And I think we are doing well.
Thank you very much, Justice Kothari. Let me move to Justice Apresh Kumar Singh. Justice Singh, so one of the things which is clearly emerging is the very delicate and difficult task of managing at one level the policy dimensions of the decisions that the government takes, and also the constitutional responsibilities that the court as an institution has. Now, of course, taking back to this, to your work at the Jharkhand High Court, it's very clear that there are huge challenges of mobility of population that has been created. This is not only limited to the migrant workers crisis that we are facing, but also other governance challenges that we are facing across the country. In this context, if courts have to prioritize the cases that they are taking when it comes to adjudication, what kind of standards that they should effectively adopt? Or alternatively, what kind of standards does your court adopt in determining what kind of cases you will take at this point of time?
Thank you, Raj. Very good evening to you, all the learned speakers, sister and brother judges, and the audience. In fact, before coming to your question, I would just sound a few optimistic note about this whole pandemic experience. I am myself an eternal optimist, and despite all the misery that this pandemic has thrown across the world, I really admire the ability of our species to adapt to such situations so quickly, and the ability to communicate, to analyze things, and to transmit a whole lot of information across the world and to connect to each other. So that is how our cognitive abilities have helped us to survive this, and we are sure we'll survive many more challenges. The second thing which I again would emphasize, that every one of us have realized that how little do we need to live, and how much more we have today, especially the affluent and the middle class. So that is a revelation while we are living together as a family and spending family time, in fact, for the last 2-3 months. And we also have learned to live with nature. Now, coming down to the question, you see, pandemic has thrown a unique challenge, and judiciary as the third pillar of democracy, and besides all other important, equally important sectors of the society, has also its role to play. Now, the first response obviously was expected and rightly had to come from the government, and it had to be dealt on 2 fronts. One was the humanitarian challenge to prevent the spread of the disease and to ensure restrictions in the movement, quarantine rules, etc. And the second one was to ensure that the economy and the other sectors of the society do not go on a complete spiral. So in this regard, the first issue that you had raised, our Disaster Management Act 2005, rather a comprehensive umbrella overarching legislation framed under the concurrent list subject, entry 23, I think, that is a legislation which takes care of the interest of both the states and has a hierarchical structure right from the top. The National Disaster Management Authority, the State Disaster Management Authority, and the District Disaster Management Authority. We have the Disaster Management Force and Disaster Management Fund, and a comprehensive unified view and a decision which applies, though at grassroots levels in different districts, had to be taken by the Union Parliament. And by and large, every state has respected it because of the promptness of the response and the kind of humanitarian help that this Disaster Management Authority has been able to extend at all places. Now, each sector having its own challenge, our judiciary had a challenge how to go about it when it suddenly came. We, like all others, had a very cautious approach, because the first challenge was to ensure protection of lives and control the spread of the disease. And that is how all the High Court, Supreme Court also included, and the district courts stopped physical hearing, and we resorted to virtual hearing of courts. Now, the first response was to ensure that the liberties of individuals which were at stake, those kind of cases were to be given priority. So initially we started by entertaining very important urgent cases in Jharkhand also, and in all other high courts, I believe. And thereafter, this bail matters, anticipatory bail matters, or matters relating to human rights issue, which were taken up through suo motu PILs or somebody also coming to the court. Gradually, as the pandemic continued and the lockdown continued, we felt that we could not sit with our hands closed, and we had to take a decision to entertain more and more number of cases which were of different nature. And accordingly, this High Court also took a decision both at the High Court level and at the district level to open up, in the sense that filings were open of different kinds of cases. And at the same time, the pending cases which were ready for hearing were also those which could be heard through virtual courts without the physical presence of the counsels or the parties requiring to come to the court. So these things unfolded gradually, and today we are in a situation where the entire High Court, all the benches are working, And similarly, in district courts also, with use of technology, the district courts are working. Every PO is working. But again, the question which you asked was how to prioritize. The prioritization work, basically, the first criteria was to attend to the humanitarian issues and to the civil liberties of persons, where those who were in jail. There was a direction of the Honorable Supreme Court to take care of the under trial prisoners or convicts who had less than 7 years of charge or imprisonment, and the state level advisory committee of this state also sat, but we did not have any overcrowding of jail in that sense. But many people were released. Then there were problems of furnishing securities and transportation from one district to another that were also taken care of because of the initiatives taken. And let me tell you, in all this, the courts in our state and other states also, and the apex court has this particular concept in mind that we cannot stop access to justice, because that's an inseparable part of the rule of law. And that is how technology, which is now becoming a game changer and has come to stay, and the virtual courts and the traditional open courts are coming to coexist, as is coming from the top court and the Honorable CJI also. So these are going to function, and we are gradually putting ourselves in that mode. We are having the legal framework, the e-filing rules, the video conferencing rules. Then we are strengthening our infrastructure and also ensuring that training of judicial officers and staff, and also taking on board the lawyers and the litigant community, so that the courts can function to the maximum extent possible.
Thank you very much, Justice Singh. That was
a response.
That was a very comprehensive and very useful response. As we've had a fantastic set of responses from our very distinguished judges. We are, as you know, live on Facebook and YouTube. I hope you will be able to send the questions that you intend to have. After this segment, we will get into the Q&A session. Let me move to Justice Geeta Mittal. Ma'am, one of the things that has happened in the crisis is that the other dimensions of justice delivery mechanisms or issues that courts have to deal with haven't stopped. The J&K High Court itself took suo motu cognizance of the increase in domestic violence against women. There are a number of other suo motu initiatives or efforts courts are in. So does this pose significantly added stress to our institutional capacities beyond what you normally otherwise do within our court system during this time?
I'd just like to comment one word, on what has been said by my brother judges.
Please, ma'am, go ahead.
We are when we are talking of access to justice, and we're talking of virtualization of courts. I've said this when I've come on your panels earlier, but since I have the benefit of the company of judges from all over the country, I want to point out, I really want them to highlight this issue which I've been flagging repeatedly. Virtualizing constitutional courts is not ensuring access to justice to the last man. For instance, in Jammu and Kashmir, it's such a challenge to be able to ensure e-connectivity to most of my courts. I think by today also I had that hearing where I'm monitoring e-connectivity of the courts. Barely 50% of the trial courts are e-connected. And then too, there are issues with regard to digitization of records, e-filing modes being available to the litigants and the lawyers, So, especially now, I think Chennai, it may not be a problem. Kerala, it may not be a problem. Sanjeev may not be having a problem in Kolkata. But certainly, Brother Amrish would be noticing that this has to be a problem in various districts in Jharkhand. I'm sure there are tribal belts, there are tribal areas where e-connectivity would not have reached so far. So this sudden transition to virtualization, must be definitely having an impact on access to justice of these areas. Of course, I've always been saying that access to justice is not necessarily access to courts. It goes much, much beyond, way beyond. But other than that, now we also spoke of, two of my brother judges mentioned closing of courts. Closing of courts is never an option at any point of time. In several countries, they have declared the justice delivery system as an essential service. In Australia, for instance, I've had friends who have been going to court. And we in this country haven't needed such a have shut down our courts. For instance, when I had to say, initially I was very, very reluctant to stop any kind of, any kind of working. And my first orders, oh, they say my internet connection is unstable. I'm very sorry.
No, we can hear you, ma'am. We can hear you.
I
Keep going.
know, no, I just got this message, it's a challenge at any point of time, and I've come back to my court to ensure better
But we
connectivity.
can hear you very well. Please go ahead.
So, so therefore, my first order in our court was to say that we will not accept ordinary filing. And we identified, as others have said, what were urgent cases. Again, what has been urgent is what has been listed by Brother Singh and Brother Kothari. But also, we included one very critical area was that of domestic violence and maintenance issues. We tend to be forgetting that critical need. Also, needs of the disabled who needed help, needs of the families of the COVID warriors who we were ignoring completely. We were dependent on the COVID warriors and who were ignored. But in a similar way, what we have experienced is that though we as judges have been willing to open our courts to the lawyers coming in with social distancing and having provided several precautionary measures, we are actually scrutinizing who wants to enter the complex at the end of bottom of the road, before they can even turn into the road leading to the high court, that you're making sure that only people whose cases have been identified as urgent, and that to only lawyers and litigants in person, enter the court. In Srinagar, I got a complaint that my registrar judicial is not even permitting lawyers, drivers, or court clerks to enter the court building with them. But despite that, the lawyers themselves are very reluctant to join the hearings from court premises. I've seen that bar associations in the Supreme Court in Delhi, in Punjab and Haryana, as well as the Bar Council of India has been requesting the Chief Justices to open the courts and not to stem the hearings in the virtual mode. But here I've experienced a different phenomenon, though now few lawyers have started joining the proceedings. So far as the nature of the proceedings is concerned, I think access is a huge issue. There are several red areas and containment zones, and even litigants are unable to reach the lawyers. There are many lawyers who are unable, whose residence may be in a green zone, but their office is in a red zone. So they're unable to access their offices. We as a court have offered to send digitized versions of their files if they want to argue, but we haven't really succeeded. But slowly, there is an increase in the quantum of work. So far as the nature of the litigation, because the filing is so less, so we are unable to assess as to what is the kind of work which lawyers are wanting to do as of now.
Thank you very much, ma'am. Really appreciate the issue of domestic violence that your court has also responded to. Let me move to Justice Nambiar. Justice Nambiar, there is clearly a very strong impetus that this crisis has provided for the ability and even acceptability of the use of technology. While this was already evolving quite rapidly in our country, this crisis has, let's say, expedited it. Now, data privacy has resurfaced as an important right during this crisis, triggered by the use of Arogya Setu app to battle COVID-19. Without, of course, making any reference to individual apps and things like that, I believe also the Kerala High Court identified a set of directions for Sprinkler as part of its COVID-19 data management efforts. And I believe there are further developments on that. Keeping those specifics aside, it'll be very useful for you to reflect about how do we deal with this potential data pandemic as not just a consequence of the health pandemic we are facing, but also a greater acceptability of use of technology, which has the potential to invade and even possibly undermine civil liberties?
Raj, it's a tricky issue because this is one problematic area as far as the judiciary is concerned. And especially when we're dealing with a situation like the pandemic. You see, technology no doubt is good, and as long as it is enabling in some way for the judicial process. I've always been a votary of advancing or using technology for helping us and assisting us. But as Justice Mittal pointed out, you cannot embrace technology in your workspace unless you have the necessary supporting infrastructure to facilitate it. And in many parts of our country, you do not simply have it. Why even in Kerala, you would be shocked that and on some days when we do a video conferencing, you don't have the necessary bandwidth in the court, and therefore we are operating from our homes where we have the benefit of a fiber connection or something like that. So these things do pose a problem, and I believe that the second thing that I would like to emphasize on is you do not embrace technology just because it is there, because not all technology is desirable in a workspace like ours. For example, if you're talking about artificial intelligence, there is enough software out there which would enable you to read the facial expressions of a witness, for example. Now, if you were to have a cross-examination of a witness over video conferencing, and you insert the software in your computer, which will quickly tell you whether the witness is actually lying under testimony or is he speaking the truth. Now, if you start using that, the question would be, is there available technology? Yes, there is available technology. But is it desirable? Absolutely not, because that would be flouting the very law that is laid down by our courts in cases like Selvi, etc. So these aspects, I think, have to be dealt with, and your movement forward in the judiciary using technology has to be a very circumspect one. That's on the aspect of embracing the technology. Now, coming to your point regarding data privacy, that's another problematic area precisely because we came into the picture very late. 2017 is when the Supreme Court actually gave the judgment in Puttasamy, and for the first time we recognized privacy as a fundamental right. Not that privacy was not treated as something akin to a fundamental right from the days of Karak Singh with dissenting judgment of Subbarao, and then later on in Gobind and other cases. But having recognized privacy as a fundamental right, although not absolute, we now have to grapple with the situation where you're parting with data and you want to ensure that that data is protected in some manner from abuse by a third party. Now, you should understand that we decided to emulate or follow the system that is prevailing in Europe as against what is there in America. So while our privacy, our fundamental right to privacy is now seen to be guaranteed or protected, not through control of state action, but as as a means of providing securing the rights of an individual. We try to emulate the practice in Europe. The question is, do we have the legislation for it? We still don't have a data protection legislation in our country worth its mention. We're still relying on the provisions of the Information Technology Act. You have a personal data protection bill that is in the making. When it will come out, we do not know. But having said that, till such time as we do have one, what is it that we prioritize on? Because every aspect of data protection involves a question of prioritizing between the various rights that come into play. On the one hand, you have the state's obligation to protect the public health. On the other, you have the private right or the fundamental right of a person to protect his data. Which do you prioritize in a given situation? And you're talking about a right which is so fluid, because I believe that the moment we decided to use Google for our queries, we mortgaged our data privacy to a large extent, and this happened quite a while ago. The peculiar problem that we found when we were dealing with the sprinkler matter was that suddenly you had an interest in protection of data, which was being collected for the purposes of identifying persons who were tested positive in your vicinity. Now, there are divergent views as to what kind of app is most suited. And if you read some of the technical literature that has been floating around, you find that a GPS-based system is largely frowned upon because a GPS-based app has the propensity to extract a lot more of data from the device where the app is installed. And a GPS-based app is notorious for its privacy concerns, because even a simple app which you would use for running, for example, like this Strava app, Strava ran into a lot of controversies in USA because a lot of the military personnel who were using the Strava app as part of their running in the morning as an exercise, they did not know that unknown to them, their location data was being shared or being tracked by the app. And this soon enabled a lot of third parties to find out or locate or identify the location of various military bases in the United States. Right. So if this is going to be a threat, then a GPS-based app is not desirable. And if you actually look at the recent experiments that have been done in Switzerland, for example, they have actually preferred going in for a Bluetooth-based app, because a Bluetooth-based app, as opposed to a GPS-based app, would largely insulate a lot of data from being extracted by a neighboring device. So you would not, for example, get the location of the person. You can have anonymized data in your phone being tapped by another phone with the same app through the Bluetooth device. It would only share that much of information which is required for a person to know whether he is in the proximity of a COVID positive patient or not. But none of these apps at the end of the day are foolproof, because they do have their limitations. They do have their fair share of problems as well. But the Swiss example is encouraging, because what they've done, and I think that is what we should be thinking of here, is understand the privacy concerns and then team up with competent people who can provide the technical solutions before actually rolling it out into the market and amidst the citizenry. They have in Switzerland, they've actually developing an app in collaboration with both Google and Apple, so that you have two platforms, both the iOS and the Android, on which you can install the app so that it can seamlessly work across all devices. So things like that would probably help in creating an app which should ensure protection to what little extent we can. But again, the basic problem is you don't have a legislation by which you can get a right for data protection yet. And till such time as we do that, again, the mantle falls upon the court to decide what is the right, what is the extent of protection. So this actually is what was weighing with us when we actually decided the sprinkler matter, and we had to put in place certain directions so that we could protect the data that is already extracted.
Well, that was thank you very much, Justice Nambiar. That was a very delicate balancing act, and I'm sure the jurisprudence developed is going to go a long way in helping us deal with these issues in the future. Justice Banerjee, I want to slightly move and shift us into a discussion surrounding the legal profession a bit. One of the less talked about aspects of the crisis is also the challenge that lawyers are themselves facing, and in that process litigants as well. We hear that a number of lawyers are even struggling, particularly at the middle to the lower level when it comes to practicing law. Several of their day-to-day cases that they would have otherwise been part of are either stalled, or such courts at the lower level are not functioning. So my question to you is that, what kind of role do you think that high courts like yours can play in many ways shaping the policy of dispute resolution at the lower level, particularly at the district level, and to what extent that can potentially help the lawyers who are practicing, let's say, a level below the high courts and further down?
Yes, that's a very pertinent question, but I have to be very guarded and I have to be politically correct in what I say,
Oh, sure.
because this deserves a much larger platform and a much longer time, to talk of.
Sure.
Now, we've had, just as several other high courts have received, public interest litigation saying lawyers should be given some kind of an allowance, particularly junior lawyers and those practicing in the districts who do not have access to funds and who do not have any other opportunities for generating income at the moment. Now, there are several issues over here. The Bar Council also steps in, and then there are other factors. But before I get into this, I just want to take a cue from what Chief Justice Mittal said about, access being very limited on the virtual platform. And, we are accused in India of basically punishing the poor and letting the rich go, because, the rich have access to sophisticated lawyers who, even if they cannot, win, have sophisticated tools at their disposal to prolong the inevitable, but the poor do not. In fact, I had a call as the senior most puisne judge in the Calcutta High Court. I had a call from one of our more remote districts where some lawyers said, "Sir, we do not have smartphones. There are a couple of lawyers over here who have smartphones and they have taken all the bail matters, because on the virtual platform without a smartphone you cannot function." So you got to think of the litigant also, who probably wants to access and has no means to access because he does not have access to technology. Now, coming to the question on lawyers, there are several lawyers who have been very seriously hit. But we must also, kind of take one reality into consideration. There are several people who are enrolled as lawyers. Less than half of them work or operate as lawyers. There may be several thousands who come to court complexes on a daily basis, but less than a quarter may be involved in any litigation or related work on a regular basis. Yet, when it comes to decision making, there is one man, one vote, and therefore everyone gets a chance to vote, and those who work or those who do not work, there is no distinction between the two. The other problem is that with cars and other gadgets being available on loan, with credit cards being, so freely accessible, young lawyers make investments in such items which at our level were considered luxury items and came much later in the day, almost immediately after they get into practice. It's easy to pay them off in installments as long as there is money rolling in. But when the trickle stops, then it becomes a burden, which it has become right now. But there is not enough litigation going around on the virtual platform which will support all the lawyers or most of the lawyers who need the money most. There, of course, exists a level of lawyers who do not actually bother about a 3-month lockdown or a 6-month lockdown or maybe even a couple of years. Now, we must look at the functioning of the Bar Council over here. There are some emergency funds, there are some medical funds, but no real funds for the present purpose. And here we've got to see how many people we are rolling out as so-called lawyers from the several law colleges that we have, and what is the quality. We churn out lawyers in batches, but the quality sometimes is not really the desirable. So therefore, if you talk about lawyers who are enrolled, there are a whole lot of lawyers who are enrolled. Lawyers who were practicing and were earning and have been hit. Yes, the lower rungs have been, particularly in the district courts, if not some in the high courts also. And there really is no contingent fund to, safeguard or provide some kind of a safeguard for these lawyers. And public interest litigation has only helped in the odd case for, extreme dire financial crisis. On a general level, it really has not helped, because public interest litigation can result in orders. We can't generate money.
Yes, that's true. Yeah. Thank you very much, Justice Banerjee, for that. In fact, you made a very nuanced point, which I'm sure you may be aware, that a few years ago, no less than the Bar Council of India chairman did speak about it when he said that over 40% of lawyers in India are, in the sense, their identity are, doubtful, and he even used the word fake lawyers. And that is a matter that is the Bar Council of India seized of it. So I can imagine kind of issues that you discussed today. Thank you very much for that. Let me move to Justice Singh. Justice Singh, the Supreme Court order with regard to guidelines of courts to function through video conferencing marks a very, let's say, tectonic shift in Indian litigation and adjudicatory process. Of course, such discussions have happened in the past. There have been committees set up. Now, video conferencing, evidence-based recording of guidelines, and helpline for technical grievances are some of the current proposed implementations too. What challenges do you foresee at the ground level? What do you think the whole framework of e-adjudication, technology-led dispute resolution, how can it impact the functioning of high courts in particular? That's the same.
Yes. High courts, in one sense, are in a better position in the sense that digitization of records in high courts, by and large, have been done across the country. In our high court also, the pleadings of the disposed of pending cases and fresh filing cases have already been done, are being done. And now also, when we are holding courts through video conferencing, we receive the scanned files in our residence. Though the most advanced form of access of these scanned files is not yet ready, which should be done in coming weeks or even a few months, one or 2 months. But then High Court and judges in the High Court are in a much better position. District courts digitization work is going to be taken up in right earnest in our High Court also, and as per the initiatives of the E-Court Committee, Supreme Court, throughout the country. In high courts, what my experience has been and our experience has been that the moment we started functioning in full strength through video courts, there were almost 90 to 95% attendance of lawyers through their own residences, through their chambers, through smartphones, through their laptops, computers, and connectivity was not an issue. In fact, yesterday, a lawyer was attending my court from Godda district. His case was there on the list. He could not come, but he attended court. The more progressive steps that is being taken during the pandemic because of the initiatives of the e-project is the laying down of the e-filing framework and the video conferencing rule. And at the same time, strengthening of this hardware and software and more adoption of technology by the stakeholders, that is the litigant public and the lawyer community. So we are in a much better position, the High Court. In the district courts, of course, this is a challenge, and digitization, if it happens as soon as possible, then the district courts would be able to function in a much better fashion, because ultimately they, in spite of holding courts through video conferencing, they have to access the physical files, every presiding officer. And the lawyers also do not have all that enablement. But one thing which is happening because of, again, initiatives of the E-Courts Committee is the starting of this e-Seva Kendra in all district courts across the state and across the country. Here also we have inaugurated one in High Court and one in Godda district, and rest of them are almost at the stage of coming up. So these are basically facilitation centers where those who do not have that facility can come and do e-filing. The scanner will be there. They can, in fact, address the court. The PLBs will be there. So these are very progressive steps being taken. And to slightly expand on the topic, the use of technology has been the initiative again to cut short on the manual process delays, that is process automation or use of artificial intelligence now going to come in the future days. These are going to at least help us in avoid repetitive kind of work which we do, deciding the same nature of cases, doing the same search of case law and facts, and then deciding cases. So I think every one of us are getting geared up to face the challenge, and this pandemic has acted as a catalyst to that. The inertia or the resistance to change has reduced to a great extent from the stakeholders.
Thank you very much, Justice Singh. We are coming close to the end of the first segment of our program. Before we begin the questions, we are of course live on Facebook and YouTube, and I have already received over 75 questions, and I hope to get back to it very shortly. Let me move to Justice Geeta Mittal. Justice Mittal, you are of course very familiar and have been deeply concerned about the huge number of pendency, the 3 crore cases pending across the Indian judiciary. Now the question is, can artificial intelligence help expedite backlogs? People are talking about new generation of technology. Or will the reach of justice become restricted by India's limited internet penetration and create a new form of digital divide exacerbated by the lack of access to justice for people who simply don't have technology, bandwidth, and resources? Will e-courtrooms go beyond COVID-19 to become the future of dispute resolution and justice delivery mechanisms? Justice Mittal.
The first thing that we must all accept is that there can't be any doubt that we have to reach out to technology and ensure and encourage e-courts everywhere. To achieve this, we have to ensure the availability of technology first of all, and coming to use of artificial intelligence will be prospective, but if it has to be resorted to, before that we have to energize the e-court project in every district, in every taluka, in every mufassil, in every civil court, and every criminal court. Until we do that and we interconnect systems, justice doesn't run only by operation of courts. The criminal justice system has to be integrated with the prisons, with the forensic science laboratory, with the hospital administration, to ensure that doctors don't have to come to court, to ensure that production of prisoners in court is not delayed for want of security services, to ensure that production of a prisoner is not delayed because of a COVID-19 situation, where to protect the prisoner, you will not take him out of the prison. So therefore, the first and foremost step is to ensure the outreach of the technology to the remotest corner, Raj. And only thereafter can you then to ensure that it is efficient and efficacious. And then even digitization is a challenge. I find that keeping in view the nature of the topography of the state or the union territories or the volume of work, to get people to come in to assist us with digitization is itself a challenge. You have to hold out all kinds of motivations to persuade people to assist us in digitization in the district courts. So while High Court becoming efficacious and using digital e-courts efficiently and efficaciously, is a very, very plausible situation. But to ensure that the last court in Maharashtra, in Andhra Pradesh, in Karnataka, the tribal belts in Jharkhand and in Chhattisgarh, that even the last tribal in the Northeast is able to have the benefit of technology to access the courts. To bring in artificial intelligence to assist us in the courts, I think we'll only be doing it on the surface. You'll be able to do it in the Supreme Court. You'll be able to, bunch cases in the high courts. You'll be able to work templates in constitutional courts. but I don't think you will be able to make a difference in the trial courts. I watched the system in New York. In the New York legal aid system, they had template, they had forms where a litigant could walk in and just fill up a form. If his, and they had templates for rent disputes, for matrimonial disputes, for insolvency, bankruptcy, for credit card difficulties, and they could just fill up the form, and the system used to roll it out and work out and help these people. They didn't need lawyers, and judges had a very, very minimalistic role. So but these are systems which have evolved, and technology has has evolved and reached a very high level. But in our country, the first and foremost question that we must ask is, has technology reached you? And to ensure its outreach, and then thereafter, certainly artificial intelligence can help us in resolution. It ensures that identical disputes get bunched and are easily put out of the system without every case drawing a different judgment from a different judge. So these are all tools which will help justice dispensation in a large way. But I keep harking back to the base. You know what, we have navigated in this state. Overnight, the legislation changed. None of my courts had the central acts which became applicable with effect from 31st of October. So it's so it's really given me an opportunity to see the difficulties which we are grappling with, and I'm sure the problems must be the same in the rest of the country.
Thank you very much, ma'am. Justice Nambiar, let me take that question back to you, but also to say, does this have the potential to be, let's say, our cell phone moment of India? If all of us, I do belong to the age still where we transition from landline to cell phone. And today, most households, they don't even have a landline in that sense. So is this an opportunity for courts to seriously consider a large-scale, substantive, institutional reform in which technology becomes a heart and center of reforms in the adjudicatory process, not just at the Supreme Court and High Courts level, but all the way to the lowest courts?
Raj, I think largely the philosophy that should underlie the approach that we should take is one of technology enabling you to do something, right? So while I would certainly not advocate for a complete transition overnight into with technology, which would be disastrous.
Correct.
We should take it in phases. For example, as Justice Apresh mentioned, this has certainly been a catalyst for triggering further developments in this field. But at the same time, I think when you're talking about simple things like video conferencing or even an electronic filing, if that would go to a large extent of avoiding or replicatory procedures like after filing, a physical file, for example, would be taken through about 5 different sections in the High Court. If one were to talk about what is happening in the High Court, they would literally retype the cause title in the computer, and then the orders have to be typed again. So if you have technology that would enable a seamless transition or seamless flow of information from one desk to the other, and you can cut short the time within which an order would be made available to the client, to the litigant, then certainly those are welcome changes that you can introduce even tomorrow. Artificial intelligence and other things which we are talking about, if it is an enabling one, if it will help reduce the time taken for receiving copies of judgments and orders, yes, certainly it's welcome. Because ultimately, when you're talking about access to justice, it is not only reaching the court, it is also getting the product of the services back to the litigant. So we have to go forward definitely, because if you look around you in society, people are conversing with each other through the mobile phones, and they're using the social media platform as a matter of as a mode of interaction with each other. I mean, it has gone to ridiculous extents in society. You're today talking about two people sitting in the same room and conversing with each other on the cell phone. So if people are comfortable with the use of that technology, then there's no reason to assume that they would not be comfortable with using video conferencing. Because it's just transporting it to a different platform. So you would, to answer your question, yes, for even simple measures like video conferencing, if it will help, for example, a lawyer sitting in Delhi, he doesn't have to fly all the way down to Kerala to argue a case before a court. The lawyer can sit in Delhi and argue the case. The judge can be here, and it will be a huge savings as far as the litigant is concerned. Yeah. So these are measures where we can certainly introduce technology to avoid prohibitive costs, to avoid unnecessary procedure, etc. But the long short of, like Justice Mittal talked about, creating templates and then, doing away with the court system altogether and the man thing, that maybe I wouldn't certainly advocate for it in the short term.
Sure. Thank you very much. I really appreciate that. So, judges, I want to say that this is going excellently well, and I have these 100+ questions now, so I'm going to take a few and raise it with you. Justice Banerjee, there's a very interesting question from Abhilasha Ramakrishnan. Abhilasha is asking something that you said earlier about e-filing. Her question is that, is e-filing of petitions and documents the future of adjudication, including legal profession? And possibly, she's also asked that how can the dangers associated with the use of technology, such as privacy and confidentiality, be avoided or mitigated?
The two parts, let me take the first one.
Please, sir.
Certainly, e-filing is going to be the future, just as digitization is going to be, just as, ease of processes, as Justice Nambiar said, maybe file tracking and things. But I do not envisage how the core business of adjudication can use technology other than inputs by way of, software or others to tell you about case law, tell you about the law, how to access that. So e-filing is going to be the future. We are probably going to come to a stage where physical filing will not be there. We will not be wasting paper at all. We will be saving a lot, and it will be environmentally friendly. So e-filing is definitely one that will happen as we overcome as we complete the digitization process in our courts and the district courts. Now, regarding data privacy, let's face facts. There is no privacy anymore. The only thing is, how do you prevent the proliferation of that, to larger sections? That's what we've got to tackle. Let's not even imagine that what I say or what I do in the privacy of my bedroom also is something which does not go outside. There are satellites, there are things which, monitor you, see you, and once these technology now, once you magnify the images, there's very little left to imagination. So the real issue is we are playing catching up. We couldn't stop our privacy being completely invaded. But with legislation and imaginative adjudication, we have to ensure that that does not become, like a matter for the entire public and the hoi polloi. It's arrested up to a particular stage and does not travel beyond.
Thank you very much, Justice Banerjee. That was very useful. Justice Singh, there's a very interesting question regarding, from Rashmi Singh, regarding adjudication and enforcement. You mentioned about, we do have legislation, but during these times, how they get enforced. One of the concerns which many questions have come around that is that to what extent, it's a very age-old question, but during COVID, the lack of enforcement of some of these provisions, to what extent judiciary is giving leeway and more differential to the governments when it comes to taking into account this extraordinary pandemic is concerned?
I would like to address this question in a different way.
Sure.
You see, as we look at it, the legal issues thrown during the pandemic may be broadly categorized into two areas. First, relating to the human rights and violation of fundamental rights, or the entitlement to right to life issues like health sector, food, etc., migrant issues. The other areas perhaps are relating to the other sectors of the economy, society, like the economy, commerce, trade, functioning of other sections of the society. Now, the courts during these difficult times can play a proactive role so far as the human rights issues and the protection of fundamental rights are concerned. There we can take a step ahead, we can entertain PILs, and we can do it suo motu also. But the other part of it, which largely depends upon adjudicating facts coming to the court over a period of time, and then analysis or scrutiny of the agreement, the terms and conditions of agreement, the legislations behind that. So before that falls upon the court, we cannot take a proactive role in those areas. And at this stage of time, because the courts primarily have a duty to ensure that the fundamental freedoms, fundamental rights are not violated because of the pandemic, the courts have been taking up that job. But so far as the other issues, legal issues which the pandemic is going to throw up, that of course will be decided on the merits of the case when the adjudicative facts have come. And then we can say that what has happened. What should happen is the job of the legislature, and they have to frame the regulations to control what should happen, like laying down different kind of yardsticks for declaring a company as bankrupt from it has been raised to 1 crore, or other sectors which the different ministries of the government have been issuing notices. But here, of course, the task for a court becomes quite difficult if the facts are not before us. So it would be rather risky to venture on that area, and especially when there are a lot of restrictions and constraints of movement and functioning of different offices, institutions.
Thank you very much, Justice Singh. Justice Geeta Mittal, there are a number of questions which are focusing on the role of courts when it comes to using broader, beyond legal analysis. For example, the law and economic analysis type adjudication. Chetan, Murli, Abhinav, Vandana, many are asking about the fact that to what extent our high courts and judges are equipped when it comes to looking at economic impact of legislation when they are determining or adjudicating issues surrounding law.
Are we discussing it in the context of the impact of the pandemic?
And beyond. They're asking both, yeah.
Then, let me tell you one very interesting fact. One of the questions that I asked the state to file before us was how many criminal cases have been registered during these 3 months. And interestingly, we found that, there are hardly any law and order issues, mostly because of the lockdown, and very few FIRs were being registered. But we did come across a few rape cases, So knowing that the police is so bogged down with ensuring people stay within containment zones and trying to keep people who are quarantined in quarantine facilities, etc., we haven't got into the nitty-gritty of those so far. But so far as law and order issues are concerned, they've really become minimalistic at this critical juncture. I think this must be the same position by and large, and you have seen only complaints of violations and excesses by the police in ensuring some of the restrictions were complied with. But so far as the economic aspect, economic impact of the pandemic situation is concerned, I think the issues are yet to arise before the courts. People haven't come to grips with that. One of the issues which is being agitated a lot, and we are seeing a lot of writings on that, is the fact that in a lot of places, minimum wages for labor is being reduced, or in some places being done away with. Labor rights is a huge issue. The wages, payment of wages to employees, and the enforceability of government directives that you cannot stop paying salaries to your employees. Then the inability of persons to meet their financial responsibilities, where they've taken loans from banks. The impact, whether the force majeure clauses, the enforceability and the impact, all these are issues which are yet to arise, Raj. And
Thank
I think we have to wait as to whether the government will roll out some legislation, as to whether the fact that there was a pandemic, there were COVID-19 restrictions and lockdowns in place, and which impacted the running of businesses. All this has to be yet to be seen for me to comment upon at this stage.
Thank you very much, Justice Mittal. There's a question for Justice Vineet Kothari. In terms of dealing with commercial disputes right now, are the courts possibly in a situation where ADR can potentially play a very significant role? In fact, many are asking, Shravan, Andrit, and Murli are all asking, that is negotiation going to be the new litigation on commercial matters, particularly during COVID and even beyond COVID, when the impact of COVID is going to be facing the business sector more strongly? Justice Kothari.
Yeah, Professor Raj, I think the question is very relevant. And since the economy has suffered a serious setback in COVID times, the consequential questions and issues which will now arise, and I have started arising right now also, because today only we dealt with a PIL in the matter of insolvency of the Franklin Mutual Fund matter, where unit holders are about to lose 28,000 crores. And they closed 6 schemes, they wound up those 6 schemes. And that issue came before us today itself. Of course, 3-4 high courts, we were told, are seized of that matter. And perhaps an SLP is also being filed in the matter. So without the specifics, I would say that commercial litigation during the COVID period and the post-COVID period is likely to arise in a big manner. And we have not only to be prepared in the constitutional courts, but even the online mediations and arbitrations will be a new norm, in my opinion. So we have to be prepared in all these related fields of adjudication and judicial dispensation for commercial litigation in a big measure. For that, I think necessary not only infrastructure is to be put in place, but suitable training to the judges, arbitrators, and mediators has to take place now, because like Chief Justice Mittal rightly pointed out, this force majeure clause, payment of wages, waiver of rentals, all these things are already burning issues, and courts are seized of them, and more such litigation is likely to follow. So I think commercial litigation is going to have a different color and shape altogether, a post-COVID period also, and we have to be prepared with that. And I think the answer lies in future, not today.
Thank you very much, Justice Kothari. Justice Nambiar, there are several questions coming from Shravan. This is the question regarding the challenge of using any yardstick to extend the period of limitation, statutory limitation type provisions, and the kind of potential cause of action. We talked about before in the early part of the show that we don't have a universal set of principles and guidelines that some other countries ended up following. And obviously there are good reasons why we didn't. Now, in the event of companies and corporations and business enterprises, domestic and international, located both in India and outside, what kind of challenges this is going to be causing when it comes to such disputes as they come before the courts?
Raj, if you're referring to the limitations and the time limits within which the obligations of the parties have to be
correct. Those are the questions that are being asked.
Yeah, the problem here is, see, let's understand what we did when the pandemic broke out. The first thing that the government of India did was it brought out a office memorandum, and which was basically in the form of instructions to the government departments, that wherever there was an obligation to perform something within a particular time frame, that would be automatically extended. And then, the particular department would get the discretion to actually determine whether the reason for the extension was actually a pandemic-related issue or not. Now, it's essentially a take on the force majeure doctrine. You're reading in the force majeure situation into a contract and treating the pandemic also as a force majeure situation. The difficulty with that is that you are entrusting the decision making to one of the contracting parties, and that in the long run may not be very desirable, and it would force people to come to the courts for a redressal of their grievances. There is also a difficulty in such a mechanism, because you would, assuming that one of the contracting parties, the government department, takes a stand that this is not a COVID-related situation, or this is not a pandemic-induced situation, then you would have to go to a court to address that issue first before you can claim the benefit of the extension that is provided by the government memorandum. This would necessarily take time, and it would not give you the immediate relief that you're looking for. And that is where legislations like what has happened in Singapore, for example, they brought out a temporary act of 2020, Temporary Measures Act or something it is called. But essentially what that does is it creates a panel of assessors who would in a situation, in a what do you call it, in a stalemate situation, it would be sufficient for one of the contracting parties who is affected by this pandemic to just send a notice to the other party. And then immediately the protection comes in favor of the person who's issuing the notice to the other contracting party. So he does not have to complete his obligations within the time. And then the burden shifts to the other party to either accept this person's version of the pandemic-induced condition, or refer it to the assessors, who would then take a decision on it. Until such time as there is a final determination by the assessors, the contracting party would get the benefit of a deferred discharge of his obligations. So I think we're really looking at a legislation which would enable an arbitration or a third-party independent assessment to be done of the situation. And this is basically something that is an extension of what Justice Kothari just mentioned. I think we need to have a legislation in place rather than everybody flocking to court to find a solution for this, for this issue.
Thank you very much, Justice Nambiar. There's a very interesting set of questions from Rashmi, Tina, and a few others. Justice Banerjee can possibly answer. The role of media representation of, court processes and court trials. This is not necessarily a COVID-related question, but generally speaking, to what extent the current approach that's adopted by media to represent what happens in courts at times sensationalize the entire, adjudicatory process. And can we do anything about it? That's the real question which a few people ask.
Quite interesting, but there are different philosophies in play. A media has to inform, but the media also has to sell. So, the perspective that the media has may be quite different from the perspective that the litigant involved in the matter has, or the perspective that the court has. So depending on the perspectives, the approaches are different. And while it's easy to be critical of the other, one must also accept that the philosophies and the way they approach the issue is always going to be difficult and different. In several matters where, based on some information, may not be the complete information, certain inevitable inferences are drawn. Now, as you know, in our judicial system, we have to have all of it play out and weigh all against the other to decide, depending on the nature of the case, whether criminal or civil. We cannot get a set of facts and instantaneously deliver a judgment. Now, in some cases, the media has to take a stand because that's what is necessary for the kind of business that the media does, or even not business, kind of service that the media renders. So yes, there is an element of sensationalism at times which inhibits and impedes the judicial process, but we have to coexist, and there has to be respect for systems and respect for each other, which may be lacking sometimes because we in the judiciary are overcritical of the media at times, and sometimes the media probably does not understand why the judiciary takes the kind of time that it takes over a particular matter.
Thank you very much, Justice Banerjee. Maybe I'll take this question to Justice Apresh Kumar Singh. Justice Singh, there's a very interesting question about, since all of you, maybe anyone else can answer, are doing sort of video conference-based presentations. This probably is from a student, Aditya Banerjee. Qualities like eloquence, body language, tone modulation, are these unavailable qualities to be assessed in lawyers in VC situation? So as judges, what qualities do you think are expected of lawyers in a video conference enabled dispute resolution system?
This again depends upon the age, experience, and maturity of an individual as a judge also. The perspectives change over a period of time. When you are a young judge, you expect something more. When you become more mature, you can understand many more things which the lawyer may not be able to convey, but you know that actually the litigant is being hit at this particular point and the fact is not being properly conveyed. Now, by and large, my approach has been not to be swayed or unnecessarily taking a myopic view of the manner in which a case is projected or argued by a counsel, but to look beyond that, look to the face of the litigant, actually what kind of injustice he is facing. And of course, then you have to make efforts to draw upon all the pleadings, you have to search for the relevant facts and ensure that ultimately the way the lawyer conducts himself does not have a reflection on the justice that you are going to do to the parties. Because ultimately the faith of the litigant in the justice delivery system has to remain intact. So while being more confident, more precise in arguments and well prepared is of course very welcome, and any lawyer, upcoming lawyer more to say, should be very prepared for that. It's not that many of us sitting in the capacity as a judge get much more influenced by how they have argued. We generally look at how to do justice to the case. But I can tell that as an experience as a lawyer, I have felt that the one who is much more better prepared is going to have a last word in the matter when it comes to the final nuances of any issue which the case ultimately hinges upon, or the outcome of the case ultimately hinges upon. So it's inculcating a habit.
Yeah, please, Justice Nambiar, this question anybody can answer. Yeah.
Raj, I think to a large extent it is academics like you that are responsible for this kind of anxiety coming from students. Your moot court competitions which you hold, and I've noticed this because I've attended many in a capacity as a judge with those moot court competitions. And I always tell the students this: when you're arguing a case in a moot court, you're basically we are assessing you as a person who's up to all his histrionic talents, etc. But when you come to court, we are actually adjudicating a cause, and as long as you can talk sense and you can just put the point across to a judge who you must understand is at his wit's end. Hearing matters, and it's no mean feat that we do. We get through a lot of cases in a day, and we simply don't have the time and the energy for rhetoric these days. So if a young lawyer will just stand up and in the context of video conferencing, if he or she can just ensure a sober surroundings and a clear voice with good equipment to carry that voice through, so long as she or he sticks to the brief and presents his case in the best light, he or she will get the order that they deserve.
Thank you very much, Justice Nambiar. Well, I have another 50 unanswered questions, and I know we can't take this any further. So I'm going to have one last question to all of you. For those students of law who are watching this program, what would you like to tell them as they experience this crisis along with their studies in law schools, but also the possible impact in their future careers in law and justice for all those who are about to graduate as well? How do you think they should mold themselves to become relevant into litigation and court practice in both during and the post-corona world? Let's begin with Justice Geeta Mittal, and we'll go through all of you.
I say that this is my takia kalam. I have been advocating this to students. I say this to lawyers, and I say it to my judges. We have inducting judges who are inducted into the system. This has been what I've been saying, and this is something which I practiced. I was a lawyer for 23 years before I came to the bench. What I would say to every young student is that there are three qualities which are essential, be it lawyering in the pandemic's COVID-19 situation, and I'm sure it will not change even in the post-COVID-19 situation. You must work hard. Please work on developing and ensuring that when this COVID-19 pandemic, these COVID-19 restrictions end, you come out having gained and improved something within yourself. So hard work, then honesty and humility. These are the three things. You persevere with these, and be it in the pandemic and be it post-COVID, whether you decide to practice, whether you decide to teach law, whether you decide to be a judge or just stay at home, being, using your lawyering skills within the confines of the home, these three qualities will take you a long, long way. So all the best to all of you.
Thank you very much, ma'am. Justice Nambiar?
I don't think that the alarm bells started ringing only when the pandemic set in. In fact, for those of you who have not read it, please read the book by Richard Susskind on with the caption "Tomorrow's Lawyers." It portrays a very grim portrait, a picture of our profession. But the one thing that comes across is that the future of the legal profession is largely only in the area of litigation, which is where we have, we still haven't ventured into too much of technology, and matters have not been outsourced as yet to other professions and other professionals. But my advice to the youngsters would just be that when they enter the profession, the two things that will carry them through is one, focus, and two, discipline. Because they must remind themselves that in the profession, they're not competing with the person who enrolled with them and who stood next to them in the enrollment ceremony. Their competition is essentially with machines these days. So when you're talking about artificial intelligence, when you're talking about software that enables you to dig out these decisions with the fingertips, something which they're already exposed to in their law schools, when they come into the profession, the only thing that will set them apart from the person next door would be the dedication and the industry and the focus which they have with regard to the profession. So as long as you can commit yourself to those two ideals, I think you should be safe.
Thank you very much. Justice Kothari, please.
I think I would like to strike a positive note in the sense that this COVID is an opportunity for law education also to reform to a large extent. Since the online and virtual thing is going to be the new norm in future also, if not as a substitute, as a good supplement to the physical course system, I think the students of this age should learn the benefit of technology and try to learn the law online education through an online education system, like the leading university of Mr. Professor Rajkumar GJU provides. I wish all the law colleges come up to that level and are able to cater to the needs of lakhs of students of law education today. And as far as the practical aspect is concerned, this is a good time for all law students to join the virtual court meetings also, because like Madras High Court, we are providing even meeting IDs and passwords to in the cause list itself. So every media people, students are welcome to join, and subject to bandwidth, of course. But this is time to join this system in action so that they will know how this system can really train them, educate them, and make them ready to work lawyers as soon as they graduate from the classes. So it's a good opportunity for all these young students. And this is my message for them, to be dedicated to this system.
Okay. Thank you very much, Justice Kothari. Justice Banerjee, please.
Yes, in short, hard work and industry, there's no substitute for that. Second is to ask questions. We know what is the law, but to try and be curious and discover why is the law the law. Thirdly, for any successful practitioner, there has to be a reputation which has to be built, because in the serious discretion matters is the impression of the judge, that how much we don't talk about is the impression of the judge that matters in the exercise of that discretion. And finally, we must all realize that every lawyer is more privileged than a whole lot of people in society. If we have an opportunity to do litigation, we must set apart some time to do pro bono work. That is very important, doing pro bono work.
Thank you very much, Justice Banerjee. Justice Apresh Kumar Singh.
Yes, I believe that there is an anxiety or an apprehension in the minds of young law students and young lawyers because of this kind of a situation. But to tell them very honestly, legal profession has never faced any glut. Maybe it's a temporary phenomena, but this challenge is also one which can be converted to an opportunity for them. And for that, hard work, honesty, discipline, humility, all those qualities which the learned speakers have talked about is very necessary. Apart from that, they should resort to taking up legal aid work, pro bono work, learn about ADR tools, mediation, which is a very successful thing. We have trained legal mediators from legal profession, and these people of this generation are much more computer savvy and tech savvy compared to our generation and even older generation. So they already have an edge in the future courts that are going to come, and there will never be a reduction of litigation or cases for any reason for that matter, the economic depression, everything which we have undergone. The legal profession has never faced a crisis of lack of work. So it's always hard work, being focused, and take up the challenges. It's a treat it as a service, not as a source of livelihood, because it's a scholastic profession, and the more you study and learn, the pleasure comes to you, and byproduct is money.
Thank you very much, to all the distinguished judges who've been part of this fascinating colloquium. On a lighter note, many of you kept saying that there are these young people out there and they have better sense of technology, and you seem to be suggesting each one of you are older. I consider all of you are young and dynamic, and age is anyways a state of mind. So I want to thank you for your extraordinary contributions to public service, each one of you. For all the listeners to this, I want to say that each one of the distinguished judges who have participated in today's panel have had a very illustrious career as a lawyer. And if they had continued to be a lawyer, they would have had an illustrious career as successful lawyers and made a lot more money. but they have chosen to contribute to public service, which reflected a deeper sense of commitment to access to justice. And that makes each one of them quite significant and truly inspirational. So I want to thank each one of you for participating in this colloquium. Justice Geeta Mittal, Justice Banerjee, Justice Kothari, Justice Nambiar, and Justice Aparesh Kumar Singh. These colloquiums are part of OP Jindal Global University and Jindal Global Law School's public interest initiative to provide opportunity for a large number of people to be part of this. I want to apologize to the audience. I have 75 plus questions unanswered. I know that the judges took every effort to answer as many questions. We will now be back on Saturday, 13th, when we'll have two colloquiums. One on justice and the alternative dispute resolution colloquium on arbitration, mediation, and conciliation. Can the COVID-19 crisis reimagine the ADR regime? I'll be joined by some distinguished speakers, starting with Ms. Pinky Anand, Additional Solicitor of India and Senior Advocate, Supreme Court of India, Mr. Amarjeet Singh Chandok, Senior Advocate, Supreme Court of India, and former ASG, Mr. Siddharth Luthra, Senior Advocate, Supreme Court of India, and former ASG, Mr. Parag Tripathi, Senior Advocate and former ASG, and Mr. Dennis Wilson, Barrister and Adjunct Professor at the University of Notre Dame in Sydney. We will also have on the same day, this will be at 12 noon, at 6:30, we will have a panel discussion on continuing legal education in India and US, upgrading the legal profession. We'll be joined by Ms. Barry Chase from the New York County Association, Honorable Mr. Justice Matthew Cooper, Judge of the New York Supreme Court, Mr. Haigreev Khaitan, Managing Partner, Khaitan and Company, Mr. Falgun Kompally, Co-Founder, Upgrad, Mr. Ronnie Skruwala, Co-Founder, Upgrad, and Ms. Pallavi Shroff, Managing Partner, Shardul Amarchand, and that will be on Saturday at 6:30 p.m. on 13 June. With those words, I would like to once again thank our very distinguished judges who have been patient and kind and generous in terms of their time and been part of this colloquium on a day when they had worked all day. Thank you very much.